Last but not the least, but the most important, right to constitutional remedies. Right to constitutional remedies. So this is the act which gives life to the entire fundamental rights. Without this right, the concept of fundamental right is dead. Okay. What does this right say? Constitutional remedies. So whenever fundamental rights are violated either by the state, majoritarily by the state, so the citizens can directly go to the Supreme Court under Article 32. Under what provision can they go to High Court when fundamental rights are violated? Article 226. Under Article 226, they can go directly to the High Courts to enforce their fundamental rights. So, how does the Supreme Court enforce the fundamental rights? The Supreme Court has 5 instruments. There are 5 instruments to enforce the fundamental rights. However, before looking into the five instruments, we will see that Parliament can empower not only Supreme Court. Supreme Court is already empowered, and also the High Court. It can also empower even the subordinate courts to enforce these fundamental rights. So fundamental rights are enforced, that is, they are given life majorly by, so whenever state, suppose there is right to freedom of speech and expression. So this is one of the fundamental right. If the state says no, you cannot talk, your freedom of speech and expression is is prohibited. So then they send the police to curb your freedom of speech and expression. So what, you can directly go to Supreme Court and say that, see, the state has done this to me, so ensure me justice. So under Article 32, we can directly go to Supreme Court to enforce our fundamental rights. Likewise, to High Court. However, even the government can, that is the Parliament can empower even the subordinate courts. Subordinate court means district courts, taluk courts, JMFC courts. All those courts can be empowered to enforce fundamental rights. However, no such provision has been done. I said there are 5 instruments through which fundamental rights are enforced. What are these 5 instruments? It's called writs. So there are 5 types of writs. So are the writs available under High Court? Yes or no? So writs are available even by High Court. Okay. However, Supreme Court can issue the writs only for in these 5 aspects. However, High Court can issue writs for any other aspects also. That is, Supreme Court can issue writs only for enforcing fundamental rights. However, the High Courts can issue writs even for enforcing non-fundamental rights. Okay. So what are the writs? Habeas corpus. What is the most important writ? So what does habeas corpus say? So with respect to writs, there are certain points you can note down. One, Supreme Court can issue writs only for fundamental rights, which I already told. Supreme Court can issue a writ against a person or a government. So person, either an individual person or a government, and to the remedy under Article 32, that itself is a fundamental right. For that also writs can be issued. Okay. So habeas corpus. So what is habeas corpus? Habeas corpus means to have the body of. Suppose to have the body of. To have the body of. So suppose your friend or some relative is kidnapped or taken forcefully by individual, some private individual or police. You can go and file habeas corpus and say that we need that person here now. So then the court directs the police authorities to bring that person and present him or her in front of the court. So habeas corpus is very, very important with respect to state illegal detention and also private detention. Mandamus, the writ of mandamus. What does it say? However, mandamus, one caveat, it cannot be issued against private individuals but only government individuals. So, mandamus say, we command. So, the Supreme Court commands the government to do certain activities. They say, you are supposed to so government has to disperse certain funds. So, the court says, you are supposed to disperse these funds. However, you have not done your duty. So, please do your duty. They don't say please and all. They just say, we command, you have to do. So, no request. It's an order. Next comes prohibit. So, this is for doing the duty. This is for prohibiting from doing a duty. So, what does it say? We forbid. So, Supreme Court says, Supreme Court, says that you are prohibited from doing this duty. However, this prohibition is available only in respect of judicial and quasi-judicial, that is subordinate courts and quasi-judicial. What are the quasi-judicial organs? Quasi-judicial organs means what? Your tribunals. National Green Tribunal is a quasi-judicial body. TRAI, Telecom Appellate, TDSAT, Telecom Dispute Appellate Tribunal is a quasi-judicial body. Likewise, there are many quasi-judicial, even when the district magistrate, district collector sits as a magistrate to settle certain disputes, he acts as a quasi-judicial body. So, the term quasi-judicial body is very, very important. Next comes the writ of certiorari. So, it says that to be certified. So, it is always issued by a higher court to lower court. That is, Supreme Court issues it to High Court issues it to lower court. So, why is this writ is issued? It's in order to, suppose a case is pending in a subordinate court. So, and High Court issues this writ, that is certiorari writ, to take the case out of the subordinate court and dispose it by itself. Likewise, Supreme Court can issue it to take the case out of High Court and dispose it by itself. So, this is the use of the writ of certiorari. Okay, last comes the writ of quo warranto. What does quo warranto mean? Quo warranto. Under what eligibility? Under what authority? See, this is applicable in the case of public office. So, what are the public offices? Public offices means these public jobs, under public jobs, executive bodies. For example, CAG is a public office, Election Commission is a public office, Supreme Court is a public office, and so your CBI is a public office, Narcotics Control Bureau head is a public office. Likewise, there are so many public officers. So, even CM, Chief Minister, is a public office. All the Council of Ministers are public office. So, there are so many public officers. So, if someone illegally holds the position of these public officers, then the court says, under what authority are you holding the charge there? What is your eligibility to hold that? So, in that cases this quo warranto is used. Okay. Okay, armed forces and fundamental rights. What are the armed forces in India? So we have Indian Army, Navy, Air Force, CISF, CRPF, BSF, ITBP, and so many military and paramilitary forces. Even the state police force is a armed forces. So is the fundamental rights which we discussed till now, is it equally applicable to all these armed forces? No. So armed forces has certain restrictions. All the fundamental rights are not applicable to them. It is being prohibited by certain acts. Navy Act is there, Air Force Act is there, and Army Act is there. Like State Police Act is also there. Next comes martial law and national emergency. Are they both the same? No. So martial law means imposition of military rule, whereas national emergency is imposition of emergency by the central authority. Who imposes it? It is the President of India who imposes the emergency. So there are certain differences. You can note it down. It says martial law says it affects only the martial laws only affects the fundamental rights. So fundamental rights are not applicable in the areas of martial laws. However, national emergency not only affects the fundamental rights but various other things. It even affects the legislative business. That is, the state government cannot enact laws. So the parliament enacts laws based laws belonging to the state government. So it affects the central state relationships. Next comes it suspends the government and ordinary law courts. Martial laws, so local government, whether it is district government or state government, it is suspended, and even courts are also suspended. So they have their own courts and they are the martial law, they are the rulers. However, in national emergency, there is no local government is not suspended. Even courts are not suspended. So why is martial law imposed? In order to restore the broken law and order. Law and order issue is there, like in Nagaland, Northeast, Tripura, Mizoram, Manipur, Jammu and Kashmir, Jharkhand, Chhattisgarh. Some law and order issue is there. Martial law is imposed. However, this is imposed when they are based on three reasons: war, external aggression, and armed rebellion. These are the three criterions under which national emergency can be imposed. Under no other circumstances, national emergency can be imposed. Likewise, there are other differences also. So here this is applicable only for certain part of the country. It can be applied only for certain part. However, national emergency cannot be applied for specific part. So likewise, there are many other differences. Next comes martial law and fundamental rights. I said when martial law is imposed, fundamental rights are suspended. So when the martial law is imposed, when fundamental rights are suspended, this armed forces, the personnel of the armed forces, whatever they do, they are not liable for prosecution. Otherwise, in the normal times, if they violate your fundamental rights, they are liable for prosecution. However, during martial law, no prosecution. So they are protected. For example, your AFSPA, AFSPA, Armed Forces Special Provisions Act. So in that Armed Forces, any act, even killing a person, no prosecution. Okay, affecting certain fundamental rights. So certain fundamental rights are affected. Affected means given life. So given life by certain statutory and non-statutory acts. So what are those certain acts? So the parliament can give effect. That is, parliament can give effect to fundamental rights by framing laws. Can the state government frame such laws? No, because it has to be for entire India. The law has to be for entire India. If it is for state government, it is only for specific part of the country. However, this fundamental rights can be affected, given effect by national government, the parliament, so that only by the parliament, not by state legislature, so that there is uniformity of application. It is applied all over the country. Okay. Next comes the question of right to property. So earlier, Article 31, right to property was a fundamental right. That is, state cannot take away your property, immovable property, not movable property. Immovable property cannot be taken away by the state by forcefully. So you can go to court and get your property back. However, by constitutional amendment during the tenure of Sri Morarji Desai government, that is Article 44, state right to property was deleted. Now it is only a legal right under Article 300. Article 300A mentions that right to property is a legal right, not a fundamental right anymore. Okay. This is the present position of right to property. Exceptions. So there are certain exceptions to fundamental rights. I already told you what are the limitations of the fundamental rights. I mean, what are the checks and balances. So there are also exceptions to fundamental rights. So in case of, what is the first exception? In case of acquiring of estates, acquisition of estates. Estate means property. So in the case of acquisition of property, so fundamental rights only in certain specific cases. So acquisition of property by whom? By the government. So in those cases, estates which have the agricultural land, agricultural land cannot be acquired by the government. So in case they acquire, they have to provide proper compensation. Even minority institutions, if they acquire, they have to provide proper compensation. Next comes the issue of saving of certain rights. If certain fundamental rights are violated by certain statutory acts, fundamental rights are violated by laws formed by the parliament or state government, that has been saved by which provision? That is, it has been saved from declaring as non-constitutional by ninth schedule of the constitution. Suppose they form a law. Most of the laws in this ninth schedule are land reform laws. So the government, the parliament or state legislature forms a law. So it violates the fundamental right. So if someone goes to court saying that, see, the government, the parliament has enacted this law which has violated my fundamental right, they have taken my property. So the court has the right to restore the property. However, what the parliament did, certain land reform acts and certain other acts, they put it in the 9th schedule. So when they put these acts in the 9th schedule, so even if it violates the fundamental rights, person who is the victim cannot go to court asking the court to restore their property. That is one of the provision. Next comes saving of laws giving effect to directive principles. Article 39C and 39B and 39C. So directive principles are principles followed by the government in order to formulate certain rules and also by legislatures to enact certain laws. So if directive principles, so in order to effect certain directive principles, they are majorly principles which are socially and economically empowering the society and citizens. In order to give effect to certain directive principles, fundamental rights can be violated. So what are these directive principles? One or two are there. One is prevention of concentration of wealth. So prevention of concentration of wealth is one, that is Article 39B, and the second one is concentration of wealth, and so both of them speak of prevention of on the concentration of wealth. Okay, both Article 39B and 39C. We will discuss it when we go to directive principle. And so first is accumulation of property, second is concentration of wealth. So in order to make laws against that, so concentration of wealth is a wrong thing, right? If the wealth is concentrated by a single person, what will the poor do? So as per the Oxfam report, top 1% of the world's population own how much percent of the wealth? 43%. So 1% of population, rich, 1% of the rich own 43% of the wealth. So in order to prevent that, certain laws can be framed. However, it is against right to equality. So if the victim goes to court, that law will be invalidated. So to prevent that, they have made a provision that 39B, 39C, if it comes, then it cannot be, violation of fundamental rights cannot be effected. So no grievance redressal in that particular case. Okay. Next comes the criticism against fundamental rights. So what do they say? Excessive limitations. So this fundamental rights, the acts are actually not rights, but however they are limitations for fundamental rights. Next is there are no social and economic rights, there are only political rights. Next is there is no clear-cut clarity, there are so many complexities in the fundamental rights. That is the third thing. Fourth thing is there is no permanency. The constitution can be amended. The constitution can be amended to change the fundamental rights. So that is one thing. Next is they are not sacrosanct. That is they are not permanent. They can be suspended. They can be suspended during emergency. Fundamental rights can be suspended during emergency. So what are the other criticisms? So preventive detention, which is made as a part of fundamental right. So there are a lot of criticisms, and there is no philosophy behind the fundamental rights. That itself is one of the criticism. Next is what is the significance? So there are certain significance you can take down. They constitute the bedrock of the civil polity. Bedrock of the democratic system. Indian democracy rests on fundamental rights. Indian democracy rests on fundamental rights. So they provide moral protection, material and moral protection to the citizens. They serve as bulwark of individual liberty. So individual liberty cannot be violated by the government. So these are few of the significance. So there are lot of significance. So the fact that we are so free for thought, speech and expression, we can move wherever we want, we can reside wherever we want, we have the right to employment, we have the right to sleep, we have the right to privacy. So many things are because of fundamental rights. Without fundamental rights, life would have been really difficult. So as I said, there are certain articles with respect to fundamental rights which are very, very important. So the article starts from Article 12. From Article 12 till Article 32, it is very, very important. You have to know by heart. You have to know by heart each and every article so that you can reproduce it in the exam. Okay. So the most important part of fundamental rights is covered. Next, we will move towards directive principles of state policy. So what is directive principles? So we have to look at the word first. So the word says directive principles state policy. So it means directives to whom? Directives to the state. What state? Not the state government, the big state. S-T-A-T-E. I told you, no, Article 12. So it is the directives to the state so that whatever policies you perform, whatever the policies you form, or whatever acts you enact, whatever act you enact or whatever policies you form, it has to be based on these principles. So this is what is meant by directive principles. So it is part of part 4. So fundamental rights is part 3. However, directive principles is part 4. Very, very important. AFCAT direct question had come. Possibility of coming in civil services also. Okay. Where have we borrowed these directive principles from? So we have borrowed it from Irish Constitution. Irish Constitution means Constitution of Ireland. Where is Ireland? It is beside England. So you can have a look at it in the world map or the map of Europe. So what are the features of directive principles? So this resembles the instruments of instruction. Instruments of instruction to whom? So instrument of instructions enumerated in Government of India Act. Government of India Act, as I told yesterday in 1935, this act has certain instruments of instruction. Instruments of instruction. Certain instructions are given while forming the act. That instructions are called the instruments of instruction. So this resembles that, and also it resembles the objectives resolution. Objectives resolution it resembles, and also it involves social, economic and political. Fundamental rights, only political. Directive principles include social principles, economic principles and political principles which has to be followed. So principles means values, ethics, ideals which has to be followed by the state or government in order to, or parliament while forming the policies. Okay. Next, directive principles are not justiciable. Justiciable means what? So even preamble is not justiciable. It means when fundamental rights are violated, as I said, under Article 232 and Article 226, you can go to court and ask the judge, sir or madam, my fundamental right is violated, please restore it. However, when directive principles are violated by the state or preamble is violated by the state, you cannot go to court and ask, please enforce it. Okay. Next is Next comes, what are the other features? These are certain of the features. So there is, constitution doesn't give any classification of the fundamental rights. However, in the book, in your book, Lakshmikant has given classification of this directive principles into 4 things. One is social principles, Gandhian principles, liberal intellectual principles. So these are the 3 criterions and some new directive principles. What are the socialist principles? So what are the articles? I am going to first mention the articles from where the directive principles start. So directive principles start from article number 37. Article 37 till article 51. So here, as Article 12 mentions state, what is meant by state? Even Article 36 also mentions the definition of state. So however, the directive principles start from the 37 to 51. Okay.